mute and turn off your video, and we will start the video today. So the webinar today. So Jordy, welcome, and Suzana. What I thought we'd like to do is start with, and thanks to the good work of questions, and please remember there's chats here, and jump on the chat line. But today I wanted to start off with the concept of resulting trusts and how that impacts on a planning and on the administration piece. Obviously, we struggle with what do we do with probate tax in that scenario as well. So let's break that down a little bit. Suzana, would you mind starting with the concept of resulting trust and where we're going with that? So from the legal concepts, and then we'll start breaking down on the practical side.
Sure, Ian. All of this, I think, takes us right back to the Supreme Court of Canada decision in Picori whenever we talk about joint accounts. And I just happened to have looked that up recently, and I was shocked to realize that that decision was back in 2007. So 13 years ago, it seems like yesterday, which just makes it quite clear how time flies when we're having fun. But in any event, that decision talked about the presumptions of advancement and the presumption of resulting trust when we're talking about assets that are held jointly between a parent and a child. And ultimately what the court decided and gave us guidance on was the fact that when assets are held together with a parent and an adult child, there is a presumption that on the death of one of the owners, the survivor is not going to get the gift by right of survivorship, but it's actually going to revert back to the estate. And that is simply a presumption. So in situations where there is actual evidence of what the intention was on the death of the one of the joint tenants, then that is going to trump. And so we've talked so much in the past about the kinds of planning that happens when we're dealing with joint assets so that we can confirm the intention is that it is to pass by right of survivorship as opposed to revert back to the estate. So those are sort of the legal principles in terms of how you can deal with assets that are held jointly when there is not clear intention of what's to happen on the death of one of the owners.
Terrific, Suzana. Thanks so much. All right. So given the parameters, Jordy, what are you doing on the planning stage with the resulting trust concepts?
So it seems that there are so let's just talk about the first scenario or the first circumstance, parent transferring assets into joint ownership with a child. So it seems to me that there's kind of two possibilities there. One possibility is that it's a true gift, and the intention is that on death of the parent, that the child receives the asset, both beneficial and legal title to that asset, and it's theirs outside of the estate and not subject to probate tax, not subject to rights of the beneficiaries under the will. That's option one. And the second option is that it's actually merely held on resulting trust for the estate, that it belongs really to the parent, and therefore when the parent dies, it belongs to the parent's estate, notwithstanding that legal title might pass to the child at death. In other words, the title looks like it's owned by the child. The child is really a trustee and holding it in trust for the estate. So those are the two possibilities there. And then it's a question of which one do you want to do? Which one does the parent want? And I think I can share my screen for a second and show you sort of the two things that I'm two kinds of ways to document it. The first one excuse me, people see my screen. The first one is this declaration of intention where you're actually gifting both beneficial and legal title. And so what we've worked up is some sort of declaration from the parent saying, look, I really mean this, right? I do intend this to be a true gift, and that the child receive both beneficial and legal title on my death. And this confirmation is trying to avoid the argument by the residuary beneficiaries of the estate to say, no, mom meant this to be part of the estate to be divided in accordance with her will, for example. And so this evidence is especially important, as Suzanne has pointed out, because of the presumption that in this situation, absent contrary intention or evidence of contrary intention, the presumption is that it is held on a resulting trust for the estate, namely that these kinds of assets would be part of the estate for division under the will. And so it's especially important to have, if this is the intention, to have something documenting that. Happy to go to the next.
Such good advice on the documentation piece, and this is a really strong document giving the clear intention. So carry on, Jordy.
So yeah, so and when does our obligation, and maybe I'll defer to you guys on this, when are we responsible for doing this kind of stuff? You know, a client comes in, let's take two different scenarios. Client comes in and says, I'm planning on doing this. And the second scenario is, I have done this. What do you think our obligations are in that regard?
Maybe Suzana, do you want to start?
Sure, Ian. I think that when it's already done, then we're in the stage where we're talking about, you know, the consequence of what has been done, because we know, and we've got the guidance from the court, that when we set up these joint accounts, they're sort of considered inter vivos gifts. So the intention as to what happens with what's left at the end of the day is determined when that gift is actually made. And we realize that the balance that could be available, if it's a joint account, for instance, is going to fluctuate during the course of the lifetime of the parties. But in any event, what is gifted is the right of survivorship. So whatever is left is what's going to pass by right of survivorship, if that's how it is set up. The intention and documenting the intention is just so crucial, because it's what's used to defend, you know, claims against either that it passes by right of survivorship or that it should actually revert back to the estate. And I think to the extent that we can have those discussions in advance, make sure we drill down into what is ultimately intended, because we all know that the goal is to avoid the probate tax, and that's the goal, but we still want to make sure that at the end of the day, what was the intention is fulfilled. And having those discussions, I think, is what's most important, making sure we understand what that is, and then how do we document or confirm that so that we're protecting the ultimate, what's expected to be done at the end of the day.
Absolutely. Jordy, the way the government deals with, the Ontario government deals with the probate tax is also a balancing act we have to consider. Do you want to start that discussion? And then Suzana, you talk about the need for primary and secondary wills in those circumstances.
Right. So, you know, historically, it was not uncommon for executors to exclude from probate tax jointly held assets, whether or not they were held on a resulting trust, on the basis that the forms talked about excluding from the calculation jointly held assets. Then we have the State Administration Tax Act regulations that make it clear that the intention is, and the requirement is, that assets that are held jointly but on resulting trust, beneficially owned by the estate, have to be included for probate if they're governed by the will that is submitted for probate. So that really took away, you know, whether we were doing it differently. I think it's quite clear now that those assets held on a resulting trust for the estate, if governed by the will submitted for probate, you have to pay probate tax on them.
And I think that's the key, Jordan, when you say if governed by the will that you are submitting for probate, because we've seen as a consequence of that determination a planning mechanism that's come about where people are creating a will for jointly held assets, a tertiary will, I think some people refer to, and believe you've got a different name for it.
Well, yeah, I mean, it depends if you're doing a completely separate will. If you're doing multiple wills anyway, and you want to do a completely separate will, I typically would just include those kinds of assets in the probated will, what I call the secondary will, and deal with those specifically. And what I'm just generating here, and it'll just take me a couple of minutes, is sort of the language that typically you would include, or some example of a language you would include in that secondary will to deal with those assets that are, yes, are held on resulting trust for the estate, but don't need probate to access because they're joint. So the bank transfers, takes the name of the mother's name off the joint account, leaving just the son. So the bank didn't need any probate to deal with that asset. Now the son is holding it, but technically it is part of the estate of the mother's estate. And so hopefully there's a second will that is governing those assets that don't need probate. And I'm happy to show that to you. Just before I do that, though, I thought maybe just a declaration. I'm just going to call this up on my screen if I could. And this is because I did show, I think, the idea of what do you want to do when there's when you're giving the right of survivorship. I'm just going to show you what you might want to include where it's a resulting trust. So here's a situation where the client has said to you, I've done this, but really, yes, I put my kid's name on the account, but it's really mine. And I do expect them to deal with it as part of the estate. And I did it because my financial advisor told me, oh yeah, put everything joint with one kid and you'll be fine. And so that has been done. And so this is the kind of document maybe where you were confirming in essence the presumption that these assets are held on a resulting trust for the estate by the child. And hopefully that will stop the child, who's the joint owner, from saying, oh, mom meant for me to get it. And so that's the idea behind this kind of document. And so I think it's a good idea to document that one way or the other. So.
I totally agree, Jordy. Having that extrinsic evidence is very important, because otherwise it's just self-serving evidence, and hard to really prove intention when you don't have something that's in writing, so to speak, that actually documents that and becomes the clearest form of intention evidence.
Yeah, and I think just for the record, as a litigator, I hope no one uses that document, because it really does cut into our work. It is remarkable the number of times we get into a case where a piece of it is being fought over and the intention evidence is floating around in sort of the ether. So it's an excellent document, and really is important, because clients are so sensitive to us expecting to give them as much planning advice as possible to avoid probate tax.
And first of all, you scared me when you said that, because I thought I did something wrong. But the other thing is, I used to joke that with every will challenge, you get a free joint asset challenge as well, because how often is that the case? But I'm just going to maybe just share my screen just on this. So I guess the point we're making is that if your clients are going to use this joint asset planning technique, that it requires two parts. It requires not only that the asset is owned jointly so that it passes from a third party's point of view automatically without probate, but also that you've got this secondary will to deal with that. And I'm just going to call up on my screen here. If I can find it. Yes, here it is. So give me one moment and I will share my screen. And so this is our sort of precedent, and I'm looking specifically at this definition, and I'll just try to blow it up a bit if I can. It's this definition of trust assets, and the idea here is that I want my secondary will to govern, any assets that are held in trust for me or my benefit, or for the benefit of my estate at the date of my death, including any assets over which I have a power of appointment. Some people also put in, including joint assets that are held on resulting trust for me. I think that this covers it, but you can certainly add more to it. and then it will be governed by the secondary will, and the child who's holding that asset, whether or not they're the estate trustee, they're still holding it in trust for the estate, and are required, especially under that declaration, they're required to take the instructions of the personal representative and turn it over to them, or however however they want to work it out between the estate trustee and the joint owner.
And I just think that's such a good point, Jordy, keeping your definitions. I know definitions are not something that are necessarily common.
Yeah.
Sorry.
Are you on mute, or am I?
I said I've got bad. Hang on. You can't hear?
I can hear you, Ian.
Oh. Jordy, you can't hear me?
I can't hear you.
Try something.
Suzana, can you hear me?
I can, Jordy.
I can't hear you.
I can hear you. Okay.
That's my fault.
Jordy, can you hear me now? All right. So we've lost Jordy for a moment. I think it's on Jordan's end that there's a problem. All right. So he's going to probably just pop back in. Sorry. See if I can get this going. All right. The next issue, of course, in planning, Suzana, and the whole concept of resulting trust is the possibility of someone imposing a constructive trust. And maybe we could just spend a moment on that, Suzana, while Jordan's calling back in. The difference between a resulting trust and a constructive trust can make a big difference in the context of planning, but also in any litigation environment. Would you mind just giving us a quick overview of the concepts, and then I can talk a little bit about, with Jordy joining back in, a little bit about some of the planning issues that arise from that. But it's just the idea of the difference between a constructive trust and a resulting trust.
Right. A resulting trust operates by virtue of the law. And so we just talked about the fact that, it's a presumption. And if we can't meet intention evidence, this is the result of how something will be decided. Whereas with a constructive trust, it's actually a claim that is made against title to an asset that is not necessarily in your own name. And so if, mom owns a home and you've made a bunch of contributions during mom's lifetime to the home, then you would use a constructive trust mechanism to make a claim to some entitlement in the home, even though you're not on legal title. So I think that's the simplest way to describe the difference between a constructive and a resulting trust.
Jordy, just while you were working through your technical issues, we were just trying to make a comparison on the concepts, the two very important concepts of resulting trust and constructive trust, and then maybe how you might deal with that at the planning stage.
Yeah, sorry about that. I don't know what happened there. So resulting trusts, I think, are a little bit easier because you know what they are. You can usually identify them because somebody has advanced the money. Of course, and I missed that, but of course, the law presumes, bargains, not gifts. So if you put in money to something, then there's going to be a presumption that you own it. And so that's, how would you deal with that? I think it's not unlike the issues about have you advanced more money to one kid versus another. And so, if we're drilling down, one of the issues, okay, tell me about your home. Oh, my son lives there. Okay, so as soon as you have this, oh, my son lives there kind of thing, I start thinking constructive trust and saying, okay, so tell me what happens. Oh, well, he rebuilt the roof and he rebuilt the, he added on and his family's living there. And I'm thinking, okay, this is what makes, estates a complicated area. It's not how big is it's a $5 million home. That's not what makes it complicated. What makes it complicated are the circumstances. And here we have circumstances. You've got one kid living in the home who's contributing to the upkeep of it, the maintenance, the construction of it, the mortgage. Those are indicia for you guys of constructive trust, right? And so how are we going to deal with that, and how are we going to discuss that with the client? What are your thoughts about, how do you see that translating into sort of a litigate, after death, a case involving the estate?
Well, I think in part it's got to come down to documenting, and if I'm getting the red flags at the intake for the planning stage, I'm going to say to my client, okay, wait a minute, like the resulting trust, we have to get organized here. We have to somehow identify it. We could put on title that the son owns 20% of the house. We do that with minor children all the time, whether we have to give them an interest in the house on title. That's probably one of the fastest and easiest ways to identify the piece of the action that particular child has stepped into. Suzana, do you have thoughts on your end in terms of that?
I think, like you said, Ian, the easiest one is to document the title. And otherwise, you're left with somehow documenting it in some other extrinsic fashion. But you can imagine it just becomes difficult if you don't have your ducks in order in advance to make those determinations and to prove to others that that was actually what was intended.
And Jordy, of course, there's also options for you at that point too, is to document it internally. So what are some of the tools that you use on a constructive trust scenario?
Yeah, I mean, I would want that to be worked out before especially if the client says, "Oh, whatever happens, I don't want there to be a fight." Well, don't. I love when people say that to me, and then their circumstances are so destructive. But so I would say, like, let's document this. Let's have an agreement. And let's get somebody involved here who can document what is everybody's responsibility, recognizing that this is existing. And what clients don't understand is they're not going to be here or some clients don't understand. Like, you're not going to be able to tell your side of the story unless we do something in advance. And so resulting trust, constructive trust things, as soon as I see them, whether or not the client ends up doing what I tell them to do is up to them. That's their decision, right? But I want to at least say that to them and say, look, I'm recommending you get an agreement in place about this.
And I think the other part of it, the other portion of it is, of course, I'll often recommend is that you've got to come clean. You've got to let the other siblings know, or you've got to, there's always this, and it happens with recreational properties a lot too, is that, Johnny's lived there for, he goes up there for most of the summers. Betty only uses it 2 weeks. Johnny does all the work. Johnny does all the repairs. Johnny's actually built a little cabin. And then it's just quietly expected that they're going to work this out on death. And it can be a huge disaster because both of them have created expectations that one might think, well, that doesn't matter. It's still half mine. I don't care how much Johnny's up there or not. I, in fact, gave him a benefit of using it. Now, once mom's dead, I want to have half and half. So to the extent that those discussions can be brought forward, obviously at the intake level, you're not going to, but I'm the same way. I'll strongly recommend, let's come clean on this and let's have a discussion, or at least let's be open about it with the family. And how you do that and all of that, it brings its own options.
And those are tough discussions, and no one wants to have them. Like, everyone wants to avoid conflict as much as they can while they're still alive. So, as practitioners, all we can really do is make the advice and give the advice, and then hope that they'll take it. And if not, that we're documenting at least the fact that we had those discussions, so that if there are problems at the end of the day, we could say, look, this was a discussion that was had, and here's how it ultimately unfolded.
Absolutely.
I think the nut of this whole problem, anytime we see the possibility of co-ownership of any asset, that is a red flag. So whether it's a documented co-ownership or a resulting trust, constructive trust, legal fiction of ownership, or post-death, there's going to be this issue of co-ownership. I mean, that is the number one problem in the States and cause of issues, because two people trying to own something together is a recipe for disaster.
Yeah, and that brings up options for co-ownership agreements, cottage sharing agreements, and those sorts of things. Okay, that's great. I just wanted to make sure in the first half we talked about the sort of core concepts of resulting trust and constructive trust, and how they impact both potential litigation issues and non matters in terms of solicitor side. So unless, do either of you have anything to add on that piece?
No, I just wondered if there were any questions from the participants of it, because it's, you know, it is a common set of circumstances, but also one fraught with many practical issues from a lawyer's point of view, and responsibilities, and adding new levels of issues. So just, I don't know if there were, but
Monitoring the chat, and there's nothing, but if it comes, I'll certainly jump in.
We've got one in.
Yeah, we're just asking if we can make these declarations that you've been sample declarations. Will we make them available? Jordy,
sure.
The 2 or 3 we've shown on the screen, absolutely.
Sure.
We'll make sure those are made available. Now, putting minors on title, Suzana, that issue is just being asked about in the chat line. That was raised in the context of when a minor receives a benefit, and part of that benefit is say that, and the child receives a significant award in circumstances where the house may have upgraded or a new wing put on to accommodate disability tools that are required. That's a scenario I've seen minor interests put on the title. Do you have any comments in that regard?
Sorry, and I didn't hear most of what you had said, so I have nothing to add. Sorry.
Well, that's bad.
There's
okay.
some typing going on in the background, so I don't know.
Oh, no problem. Okay, so anyway, I think I've covered it. The concept of putting a child's name on title is that can be derived from the fact that in a tort claim, you might have a child receive an award, and then somehow you have to document their portion of the house because, say, you've put in $500,000 in renovations to accommodate the child, the disability that they maybe have inflicted with as a result of a car accident or something, and they might get placed on their name might get put on the title, and that's just a scenario where that could happen. Mm-hmm. Would anything be put on title when you do a declaration so third parties would know? Jordy, what do you think about that? Putting any of these declarations that we're going to circulate on title?
Suzana, that was me typing, and I bought this new fancy mic, and it picks everything up, so I wasn't used to that.
Sorry.
So yeah, I mean, I wouldn't put anything on title. I mean, the whole idea here is that we want to make sure it passes without anybody, raising an issue, being able to register that survivorship application, for example. So no, but what I do have is the owner, the child owner, declare that they're holding it on resulting trust, and that's, I think, the crucial part there, because and making sure that that's binding on their estate and their personal representatives and their attorneys and guardians, because let's say they're incapable, mom dies, they're incapable, they look like they have title to the property, and their attorney knows nothing about this deal, and so says, okay, I'm going to sell the property, and now I'm going to take the proceeds, and then you're into it. So this acknowledgement is really quite crucial, in my view, if you're setting up this kind of situation where you're having a child holding it on resulting trust.
Can you just describe to me how that's mechanically done?
It's a good question, because you're not acting. I would say I'm not acting for the child, and so the way I do it is I say to them, I'm recommending you get independent legal advice about this trust declaration, but you're not the owner; it's not yours, and it's a bit tricky in that sense. I mean, the acknowledgement, I mean, it's enforceable whether they acknowledge it or not, in my view. I mean, the question is the declaration of intention by the parent. But that being said, you want the trustee to also acknowledge that they're holding it on a resulting trust. And so the, recommending ILA for them, is what I would do as a routine. I don't think I've ever had anybody do that and receive ILA. But it's not that easy. I think, it might not be a bad idea to have another lawyer involved. It's just not practically, we don't typically see that.
And when you say child, though, this isn't minor interests.
No, I'm not talking about minor interests. I call everybody a kid, whether they're 70 years old or not, because I do believe at the core, they're still always a child and a kid of their parents.
I agree. I just wanted to clarify that. The next question is it best to put parent and children on title as joint tenants or just the children as joint tenants?
So yeah, I would not just put the children on title. Personally, but I would want the parent on there. I would want, because yeah, I'm not a big fan of giving away things while you're alive. And that would be in essence giving away things. Yes, correct. There'd be a trust declaration, everything else. I'd rather have my clients on title. Not, even if it's held on a resulting trust. That's my preference. I could see why you might do that, but then you get into issues about, it's always there's a whole bunch of risks with this. By the way, we haven't talked about the risks, but there's a whole bunch of risks associated with this kind of planning. And and one of them is that there's going to be creditors of the child who's on title, and they don't know anything about this resulting trust, so they seize that property, and then you get in a fight. No, it's not really mine. It's my mom's, and you're like, well, show me the evidence of that. So I just think. I don't think
really, it really underscores the difference between legal title and beneficial interest, and it gets really complicated from a litigation perspective when that's the case. And I think in any event, whenever we're putting children on as joint tenants on anything, that we're having these discussions and sort of reading the client's the riot act in a sense of what could possibly go wrong. Because the planning stage, of course, everything's rosy, everyone's getting along, and there are no issues, and everyone is completely trustworthy. But at the end of the day, the situation can be very different.
I'm going to do some I just want to pull up something while you guys talk, and I don't want to distract everybody with my typing. So I'm trying to figure out how to stop mute. But anyway.
Yeah, mute's the far left. It's the far left button. So Suzana, can you just spend a moment? You use the really important terms, it's beneficial interest and legal title. And maybe just talk about the importance of how we should approach that with our clients, that yes, distinction.
For sure. When we talk about legal ownership, the issue is who's on title, like who will the world acknowledge as being the owner of that property. And so when it's real estate, it's who's on the land title document, and when it's bank accounts, who's on the bank in terms of the named owner of the account. When we talk about beneficial ownership, which is different from legal ownership, it's who is ultimately entitled to the asset. And so whenever we create a trust, we know that we put legal title in the name of the trustee, but beneficial ownership is in the name in the beneficiaries. And when we're dealing with the third parties and the outside world, for the most part, it's legal title that matters. And when someone is making a beneficial interest, it's very difficult for them to establish their entitlement without this extrinsic evidence that we're talking about and proof that this is what was ultimately intended.
Over to you, Jordy. Thanks, Suzanne. Jordy, did you have your typing finished? Did you want to share a screen, or we can deal with the next question? You're on mute.
Yeah, deal with the next question. I'm just pulling it up right now. So,
great. So maybe why don't we just go to the next question? If a client has invested for the both of you, if a client has invested in properties with business partners, and the method of investment is through co-ownership, is there, and there's a partnership or joint venture agreement in place, is this still a red flag, or are you mostly concerned with co-ownership issues involving family members? And I'll just start that one off because it is a red flag, and I'm involved in a case right now that it's a group of franchise, they own a group of restaurants, and they have all the business arrangements organized through agreements and so forth. And now the new stranger third-party partners have come into the mix, that being the children of the deceased. And this has caused great consternation and great tension within the business arrangement, notwithstanding the fact they thought they had it all organized. So maybe Jordy, you could speak to that first, and then Suzana jump in as well with the comments on that question.
You're on mute.
Anytime, so afraid of typing. Anytime either some other person involved in co-owning property is a red flag for me. It means that somebody else is going to be involved in this. It's this, you could have a $10 billion estate. If everything's in GIC solely owned by the testator, it's an easy plan. It's where you have co-ownership and different agreements and no agreements and what's going to happen. And so, yeah, that's definitely a red flag for me.
I agree. And at that point, the testator or the individual is no longer alive to be able to make any explanations or provide any background. And so we're just stuck with the words in the documents and the what others say was the intention. And it can be very difficult. And whether it's family or outsiders, there's always the potential for these arguments to be had.
And I see it certainly a lot rising out of restaurant ownerships. That seems to be the classic, where they're just doing their best to keep afloat and running this thing and doing well, but they sometimes don't focus on the joint ownership issue. Okay, so Jordan, did you want to say something?
Yeah, so I just wanted to maybe address here the problems with joint ownership, because this is something that we should probably cover off as planning lawyers. And so I identify them there. One of the issues is if you're dealing with a principal residence, that CRA could come along and say, oh, by the way, this isn't a principal residence anymore because your kid's on title and it's not their principal residence. There's pretty good coverage right now from CRA that says, look, if you don't transfer beneficial ownership to someone else, there's no capital gain issues. So that's, I'm pretty comfortable with that, but it's very helpful to have a declaration that they're not the true owners. Otherwise, I think CRA could quite rightly say, when you transferred it, you triggered any I'm talking about non-principal residents, but you've triggered any capital gain there. So, and I always say, confirm this with a tax advisor. Anytime I'm talking about any kind of tax stuff, I just say, do that. Some other problems with this idea of joint ownership is that one of the kids, if you're putting multiple kids, or the kid becomes incapable, and now you want to sell it and they can't sell it, or they choose not to sell it, or they think you're not capable now, or any of those kinds of issues, disputes down the road with documentation is a real problem. And if you do have a dispute, that's going to screw things up. This idea that creditors of the kid might seize it, and yes, you can probably pull out that trust declaration, but meanwhile you're spending money dealing with that. And lastly, of course, this only works if your child survives you, if the joint owner survives you. So those are just some of the problems with this thing. And I think it's not a bad idea to warn the client of these problems, because if that does happen, of course, where the child for whatever reason says, because the parent now wants to sell the property, and the kid's like, well, mom's starting to lose it, and I don't think it's a good time to sell, and I'm going to stop her from selling. It's like, that's going to be a problem. And guess who's going to be caught in the middle of that? Because mom's going to go to another lawyer who's going to say, Jordy, why would you possibly do this? This was a bad idea, and you didn't tell her about these problems, and she would never have done it if she knew that this was going to be a problem.
Yeah, it's akin to the always. I would love to hear all these people who, when the state freeze 15 years later, and the owner, the head of the family's like, I didn't do that. What are you talking about? I didn't give up control here. What are you talking about?
It was just for tax purposes. They just said it was to save
Exactly.
tax.
I own everything. What are you talking about? Okay, well that's good, and I think it's like anything in life. As soon as you bring another person into the equity portion of anything, you've got issues, and people who think they can just sort of glide through them are the lucky ones, because lots don't. Suzana, did you have any comment on that front?
No, I think the only other thing I would add is that there's always this possibility of a severance of the joint tenancy that can be brought about by even just one of the owners of the property. And so from a litigation perspective, it's another issue that we see arise from time to time that may not have necessarily been expected, but certainly one that can cause a lot of havoc, like the other ones that we talked about today.
That's a really good
Makes
point.
it even more important to, I mean, I'm not sure if you were a joint tenant, or you were holding in resulting trust, if you'd be entitled to sever that joint tenancy. But that being said, entitled is a whole different story. That you fight about entitlement after the fact. On title, it looks like I'm a 50% owner.
Yeah, to third parties, you're permitted to do it for sure. Jordy, did you say you wanted to share the screen on something now, or?
No, I was hopefully able to share the screen just on the problems outlining the issues.
That's
for your
good.
client.
Okay.
Yeah.
Good. I just wanted to make sure we went to all the trouble of finding it, that we move on without you properly sharing.
The one other point is, let's keep in mind why we're doing this, and we repeat this over and over again, but, like, what are we trying to do here? We're doing this mostly to save probate tax, right? That's why we're doing it. On a house, $1 million, 15 grand might be worth it. Probably not, for all the other issues that arise. The other thing is, one of the first questions I would ask the client is, are you planning on living in this property for the rest of your life? Oh, no, I'm planning on selling it, in a couple of years and moving to a condo. I'm like, well, all of this, planning is not, is going to be thrown out the window, and, when you sell it. So, that's another important point.
Absolutely. So, and as we're winding up here, I wanted to take a stab at this last question here, and it won't be a short answer. So, PCORI deals with joint ownership between partners and adult children. In that sense, the question is, what happens when the joint ownership is between a deceased and his or her sibling or a friend? And that's you certainly noticed that presumably at the intake level many times, Jordy. And that's a red flag. What is your reaction to that? And then Suzana, maybe you could follow up with your own comments on it.
So PCOR dealt with the parent-child relationship, and it just said that there's this presumption of resulting trust. There's no similar presumption with siblings, for example, or friends. There's you presume that's joint ownership, and with a right of survivorship, including beneficial ownership. So if that's not the case, then you better do something quickly. But it's again the same issues about what is the intention of the testator. What do you want to happen? You realize the other part is you realize that this property. Let's take the situation of a property that's not a principal residence, that's owned jointly with someone else. So you own 50% of this property as the testator. When you die, if your 50% has gone up in value, there's going to be a capital gain. The capital gain is going to be paid by your residuary beneficiaries, unless you do something fancy. And the property is going to go, if it's joint ownership, is going to go to the surviving joint owner, which is the sibling, who might not be the beneficiary. So it's the same issue about as if you had given your 50% to the sibling and not thought about the tax. So that is an important concept, because you can see how, the family cottage was always jointly owned between me and my brother. But meanwhile, it's gone up, 3 times since I inherited it. And that's going to trigger a capital gain when I die as to my 50%. So joint ownership doesn't avoid income tax. That's important to recognize. It's going to trigger. It's as if you own 50%. So that's a red flag right there.
Yeah, and I think also just delving into the reason why we'd want to put someone else on title is also important, because it could be because of, for instance, a bunch of contributions that were made to the property. So it might be in anticipation of or in lieu of some kind of a constructive trust argument and some other kind of entitlement to the property. And I think to the extent that we can delve into the reasons for that and document those will help at the end of the day too, if it becomes an issue as to why that was ultimately gifted at that point in time.
All right. Well, thank you very much to both of you. I think we're sort of exhausted these topic areas for today. We're going to go into week 14 to come back to some other drafting errors and to avoid, and some of the substantive issues that we've touched on today, but some a deeper dive into the drafting. So thanks, Suzana, and thanks to Jordy. Everyone, thanks for joining us for week 13, and have a great weekend.
Take care,
Thanks,
guys.
everyone. Bye-bye now.